Yeah. Hi, good morning, friends. This is Bipin, and today is 27th of December, and here we discussed today's newspaper, द हिंदू न्यूज़पेपर। और आज का आर्टिकल काफ़ी बेहतरीन है। और आर्टिकल चंद्रशेखर उदय सिंह ने लिखा है, जो कि बार मेंबर का सदस्य भी हैं और सुप्रीम कोर्ट में एक सीनियर लॉयर भी हैं। और ये आर्टिकल काफ़ी कंट्रोवर्शियल भी हो सकती हैं, तो हम डिस्कस करते हैं। एंड दिस सेशन इज ऑलवेज इन इंग्लिश, सो एज यू नो, let me start. So article is on the first, let me discuss word of the day. Word of the day is egregious. आज का डे word of the day है egregious. Egregious का मीनिंग होता है शॉकिंग, हॉरिफिक। ठीक है, ओके। सो लेट अस डिस्कशन today's session. So today's article name is controversy over review petition on Bilkis Bano case, and it is an egregious mistake by Supreme Court of India. So discuss start. So earlier in May 2022, Supreme Court released a statement regarding Bilkis Bano case. Let me discuss first about the what is Bilkis Bano matter. In 2002, what happening in Gujarat, we all know. There is a mass murder, suicide, and rape happening in Gujarat after the train accident, as we know. And in these, Bilkis Bano, a woman who also culprit on those days, and almost 11 people making gang rape with her and her family member. And for those, after, thank God, Bilkis Bano get revived after the rape, and they filed a case against the culprit on court. Okay. And after the following legal procedures, court gives sentence to all those victims. But at that time, when petitions were challenged in the court, these all incident happening in Gujarat, but due to some volatility happening in Gujarat, case transferred to the Bombay High Court, and Bombay High Court decided this all matter at that point of time. And Bombay High Court give 25 year of life imprisonment to all those convicts. uh, and one of the major convicts is Radhe Shyam Shah, who is a main culprit behind this scenario. Okay. And this all happening, behind that all, there is a very important factor we discussed, that after some time, so the convict lawyer file a remission petition against this. Okay. And for that, they goes to local high court, Bombay High Court. And Bombay High Court deny that review petition. So Radheshyam lawyer goes to the Supreme Court of India and challenge this imprisonment under writ petition. A writ petition, as we know, under Article 32 of the Constitution of India, and goes to Supreme Court of India and said, this is a not moral justice to me, that confined behind the war for a long time, because I accept uh, m- my my convictions period, and I am now a free and fair. So here some of the discussions we discuss as per the article. These all are my words, and article points are mentioning is that the what if mm, that remission is done. So it is happening in May 3rd, 2022. Supreme Court grant bail to all those convicts, and convicts come from bar, and they celebrate grandiose. People distributing sweets in the cities, in the street. So these circumstances, what impact on our society? Do you know? There is a question behind, under our mind, that what is the most prior thing against morality, ethics versus justice, legal justice. So, according to Gandhiji said, moral and ethical value is more prior to the justice. Even sometime we have to breach laws for make sure the legality, ethics and morality become superior. We have to breach the law at least. So these are the things which are contradicted to that scenario. Okay. So discuss some of the cases of the past which make Supreme Court May 2022 decision invalid. Okay. So first case is Naresh Sridhar case of 1966 and Triveni Singh case is of 1985. This case said under this case said High Court order never be challenged in Supreme Court or any other court under writ jurisdiction of Article 32 of the Indian Constitution. It means what? Radheshyam Shah goes to Supreme Court to challenge uh, previous High Court order of remission. Those are not accepted by High Court, and they go to Supreme Court, and Supreme Court accept that and grant bail to all convicts. What is here fine line? Fine line is writ petition because Radheshyam goes to Supreme Court under writ petition, and writ petition never be superior to challenge any high court order. So these are the fault firstly here written in article, and it is also very important to mentioning in our men's writing answer writing. Second is what? Uh, mm, V. Sriharan judgment versus Union of India in 2015. What is that? If incident happening in a state A mean Gujarat, a state where Bilkis Bano case happening, and a state B, Maharashtra, where this case are undergoing under procedure and after the convict sentenced. So under this judgment of Supreme Court of 2015, they say a state B where all legal procedure happening is an appropriate state to valid their state law of remission. What is mean? Very important. Under Criminal Procedure Code of 432, CRPC 432, which empower a state to make remission law under a state list law, they have power to remit convicts, remission for convicts, and the governor have also power under this to remit those convicts. So these are not valid in nature. That if all legal procedure happening in Maharashtra and Gujarat have a power to authorize these all factors, and how Gujarat comes in matter when these all are happening in Maharashtra, these all legal procedure happening in Maharashtra. So May 2022, when Supreme Court said, Gujarat, you have authority to make this all supervision under you, and so case of these all cases transfer from Maharashtra to Gujarat. These all are the contravening effect of this matter. And now Bilkis Gano again and again trying for those convict under behind the war, but those all are the out of the war now. So one of the important case also, which is uh, Madhya Pradesh versus Ratan Singh case of 1976, under which a state conviction time have power to implement their law for remission. It means it seems like V. Sariharan case. Naresh Sridhar case. So these are not very important, but one thing is important. Uh, in this case of MP versus Ratan Singh case, the court said No shadow doubt should be created over the previous order of Supreme Court on the matter of remission and convictions and legal procedures happening in uh, a state B. A state B, and I hope you influences all these. So, what is my mindset? What is my view on this scenario, this procedure? I think Gandhiji idea is best because always if we commit a crime in our society, society other bad element have a boosting module that they are always encouraged to do whatever to do in a bad circumstances, and though there is no an, a strict penalty against those, a strict action against those with their time limit be, without considering the human right or their ethics who are convicts, we don't be able to survive our society in a great manner, because some of the bad element always disturbed our society, and from the long last up from the Vedic period to now till now, these all are happening. So a state must be think these all matter with their ability to reasonable restrictions must be on every person for all activities. So is the article. Thank you for listening me, and hope it will very important to you. And I want you all read this article of today's newspaper, because this is very important newspaper for GS paper 2, one of the best article, and is all it's also help in your ethics paper and even in essay paper. So thank you. मिलते हैं बाद में. जय हिंद.